If you're looking to buy a home from a builder or developer, there are many different things in the contract that you need to make sure to do your homework on and review before you get into the agreement. Otherwise, you might find yourself in trouble. Hi, my name's Simon Offord, and I'm an attorney with the law offices of Peter Brewer. Today I'm going to talk to you guys about the blog I recently wrote entitled, Look Out! 2 Things to Watch For in a Builder's Purchase Agreement. The reason I wrote this article is that the builder's purchase agreements are typically custom-made agreements that are prepared by the builder, developer, or most likely their attorney. This is a lot different from a typical consumer-to-consumer sale, where most real estate agents will use standardized forms. For example, here in the peninsula, most realtors are going to use either the CAR, California Association of Realtors form, or the PRDS forms. These are forms that are specific and created by members of the real estate community here on the peninsula. These forms are created with both sides' interests in mind, whereas the builders will typically have their agreements be heavily favored towards them. Today I'm going to talk to you about 2 of the red flags that often rise in these builders' purchase agreements. One big red flag area to watch out for is the financing contingency. A typical CAR or PRDS form allows the purchaser some time to try to secure the financing that the parties have agreed to, and if for some reason they're not able to get that financing, they might have an option to cancel the contract and back out of the deal. On the other hand, the builder's contracts typically won't have this kind of leeway for the purchaser. The builder's contracts will typically require the purchaser to use a specific, what they call preferred lender, and first go through the process and get pre-approved from that preferred lender. Sometimes the builder will let the buyer then go out and use their own lender, but if for some reason the buyer can't get the financing from that lender, it doesn't matter. You're still stuck in the contract, and you either have to come up with all the cash or use the lender that they'd like to use. The second issue I talk about in this article deals with the disclosures. In a typical consumer-to-consumer transaction, the buyer is normally going to have a contingency period where they get a chance to review the disclosures and potentially get out of the contract if they find out something about the property they don't like. On the other hand, the builder's contracts will not have this kind of contingency period built in most cases. Instead, the builder's contract is going to assume that you've already received the disclosures and you know everything there is to know about the property. So once you put the ink on the paper, you're stuck in that agreement whether you like certain things about the property or not. These are just a couple of the issues that could come up in a builder's contract. There are multiple more issues that I will address in future blog articles, and so stay tuned to try to see those and to find out other things that you need to be looking for when you're buying from a builder. To read this blog or other insightful blogs, please visit our website at www.bayarearealestatelawyers.com. Thank you very much.